So, do number one, put your children's needs ahead of your own. So, I want you to try to put yourself in your children's shoes as you are thinking about and deciding the things that you must decide to address custody and parenting related issues after a separation or a divorce. So, what do I mean when I say walk in their shoes? So, imagine being told, if you didn't have a clue that there was discord in the house, that your parents are separating. Imagine the emotional shock and disappointment and sadness and grief that your children are experiencing. Imagine being the one who has to live your life for X number of years until you are out of your parents' household or households, going back and forth between two separate residences with a backpack, or having duplicate items in both places, and trying to remember where your favorite book is, or if you brought your soccer shoes with you before a soccer practice day. So most adults haven't been in that situation unless they were the child of separated or divorced parents. So if this is new to you, imagine how new and scary and disorienting and frightening it is for your kids. So try to walk in their shoes, try to put yourself in their psyche, and be sensitive to their needs and put their needs ahead of your own. This is the time to really be the bigger person. You may not want to share your children for a moment. Like, none of us want to think of having our children less than we had them when we had them in our household 100% of the time. But the reality is you can't have them 100% of the time, and there's got to be some give across both parents' playbooks on how to address the situation. So that's my number one do. If you wouldn't want it done to you, if you were a child in that situation, then don't do it to your child in this separation or divorce that you're embarking on. Okay. Number two, I want to encourage you to plan ahead, if possible, before you embark on a physical separation that's going to impact the kids. Because it's best for them, it's best for you, and if you end up in court over these situations, it's going to present best in court if you took the time to plan ahead and to be prepared to manage the physical transition of the children from one house with two parents to two houses with separated parents and maybe others in the two houses. Handle the emotional transition and adjustment of, accepting and adapting to the fact that they no longer live in a single household with intact parents who are remaining a couple and raising them together. Also, prepare the children as you plan ahead so that they are ready for the changes. So you're going to want to have a conversation in advance of, we're moving out in an hour. If you can do that, right? You want to have a conversation, get them ready, have some time for them to adjust to the idea of what's coming ahead, and thinking ahead about how this will impact them and how to best support them through the adjustment of this huge life transition for them. I'm going to strongly urge you, as part of planning ahead, to engage counseling, get good counseling advice before you talk to the children and tell them about your separation or divorce, so you can help manage their psychological and emotional responses to learning about that. And consider lining up counseling for the children as they're going through this transition. Counseling is not a sign of weakness. It's not a sign that anyone is mentally ill or just not able to cope. This is a very big life change, and the more supports you have as you go through this very big life change, and the more supports you line up to help support the children and help you support the children through this change, the better off everybody will be in the final outcomes. Do number three. Do minimize the number of changes in the child's environment as you're making this transition from one household to more than one household. And what I mean by that is, if it can be avoided, try to keep the other constants in their life constant for them, at least for a while. So if you can avoid a change in daycare providers, if you can avoid changing their school during this transition, if you can avoid introducing new romantic partners or new household members, or blending families and introducing them to living with stepchildren right away, that will give them the time to adjust to the two household living situation before they are adjusting to other big changes in their environment. I think it's important for you to know in advance what's involved in court, what are some of the key terms you need to know and understand that the court will be addressing, and then have an idea of how the court would decide custody if they're required to. So at this juncture, I want to say that court is not your only option, and I'm going to argue to you and suggest to you that court is probably your worst option. And why do I say that? Well, there's a lot of reasons, but court is adversarial by nature. Every court case has a person A versus person B. So the versus means you are adverse to each other. You are adversaries by definition in that setting. Doesn't mean you have to go for the jugular and wage war against the other party, but the system is kind of built around that adversarial situation, and it tends to promote that just because it was built that way. So you have other options. You can figure this out on your own, sit down as level-headed parents and say, all right, we're not good together, but we're both decent parents. We're both reasonably flawed parents, because all of us are, and let's figure out what works best for the kids and our new living situation, and how to work all these things with everyone's schedules and such. That happens. It's not impossible. It is not necessarily the predominant way that these things get addressed, but many, many people can successfully do that. And then it's smart, if you can, to memorialize that in a written agreement, and maybe even submit that agreement to a court to have it approved as a court custody order. If you can't do that on your own, you could access mediation or hire collaborative lawyers to help you do that. Mediators and collaborative lawyers will help you stay out of court, stay in control of your final outcomes, make the process safe and civil and respectful for each of you. But if court is the only way for you to go because those other options aren't workable, your partner won't engage in those other options, or you've tried those other options and they just didn't work for your situation, then what I would suggest to you is that if you end up in court, you get a lawyer who is a problem solver and will help you try to structure settlement discussions and negotiations so there is still a very likely outcome that before you let a judge preside over a trial concerning your children and making a decision about your children for you, that you have an attorney working with the other side across the aisle, trying to negotiate a settlement short of trial. My fifth do is please do remember that your children have a right to love both of their parents unconditionally. Try to keep in perspective that even though the other parent is your ex or is about to be your ex partner, wife, husband, etc., they are not your child's ex. They are your child's forever parent, just like you are. Now we're going to turn to the don'ts. Number one, this one comes up quite a bit. Don't talk to your children about adult issues, including court. Just don't do it. Don't talk about court. Don't talk about custody-related issues. Don't talk about child support or your feelings about the other parent's new relationships and things like that. Just don't do it. It's not good. And if you end up in court and the judge presiding over your case finds out that you have been bringing the child into the legal arena by using them as a confidant, treating them as a friend, or trying to win them over to your side or speak out poorly against the other side, that will not bode well for you. It's bad for your child. It's bad for your custody case. My second top 5 of the don'ts in handling your custody case: do not bash your ex to anyone. I'm going to give you a limit of that in a minute, but to anyone, but most especially the children. It's your job to make the other parent lovable to that child. It's your job to paint the parent and the other parent in the best light possible. Now, I'm not saying lie to your children if the other parent is drunk or is abusive or something like that, but do not bash them. Your issues as a former romantic partner with that person are not your children's issue with their parent. So don't bash your ex or soon-to-be ex to the children, and don't bash them anywhere else except where you have privacy and confidentiality, and I'm going to give you the limits for that. That is with your attorney, with your therapist, and with your priest. So you got 3 places that you could talk honestly about your feelings, about the strengths and weaknesses of your co-parent, but don't put it on social media, don't talk about it at the school concert, don't talk with the parents on the sports sidelines about it, don't even talk to your very best friend, because things have a way of getting around and your child doesn't need that. Your child is still in the same circle of people that they have always been in, and so if you are poisoning that well for them, you're doing great harm to your child. My third don't say, don't do, don't write, or don't post anything that you wouldn't want a judge to see or hear. So for many people that may mean take a break from social media, and that's probably not a bad thing. We actually advise our clients to do that if they can, and if they can't take a total break, keep your social media about recipes, vacations, puppies, happy things, share funny memes that have nothing to do with relationships or parenting, but don't post about your court case, your breakup, or any of that, or new relationships, or your feelings about your ex's new relationship. Keep it out of the public forum. Also be very cautious about how you communicate by phone, in person, or by email or text with your ex, because those things have a way of showing up in court. So again, if you wouldn't want the judge to see it or hear it, don't write it. My next we're on number 4. Don't coach your children on what they should tell their attorney, what they should say to the judge in court, what they should tell their therapist about the custody situation. Just don't coach them. Let them have their own thoughts and opinions about the situation. Don't interrogate them after they've been spending time with the other parent and they come back for your parenting time. And do not record the video record voice or video, audio or video of your children for the purpose of getting their reaction to having to separate from you, or their reaction upon being brought back from the other parent as evidence, right? You don't want to record them as evidence. Judges frown upon this. Children will, depending on their age and maturity, will potentially understand that that's what's happening. So that is really not appropriate. My last don't. If you can avoid this, don't let a stranger in a black robe decide what's best for your children. And in order for that to happen, I want to encourage you to be reasonable, to be realistic about likely outcomes, and that means getting good advice from an attorney if you've got an attorney in your corner about what is likely to happen. Don't ask for the other parent to have zero contact if your attorney is saying, well, there's not a basis for this court to award that. So set your expectations at a realistic level and be prepared to compromise. Resolving your case on terms you can accept through compromise is going to be better for you and better for your kids.